Good evening. Welcome to MPT's Estate Planning webinar featuring Elsa W. Smith. This presentation is to prepare you for National Estate Planning Awareness Week, or NEPAL, which takes place this week, October 20th to October 26th. Just a few housekeeping reminders. You are all muted. Please utilize the chat and the Q&A feature. We will have time for questions at the end of the presentation. However, we will not be addressing any specific situations. And as always, this webinar will be recorded. Just a little bit about me. My name is Kalisha Colbert. I'm the Plan Giving Manager at MPT. I am a part of the Major in Plan Giving team under the Development Office. And my primary role is to be the leader of the Legacy Society, which is a group of generous donors who have named MPT in their will or estate plan. And I'm also responsible for educating the community about estate planning and charitable gift planning. Just a full disclosure, this webinar is not intended to give legal or tax advice. Please consult your professional advisors about your specific situation. Now to introduce our speaker. Elsa W. Smith, Esquire, is the founder and managing member of the law offices of Elsa W. Smith, LLC, a sought-after estate planning firm serving Maryland and the District of Columbia. With over 20 years of experience, she helps individuals and families gain clarity and protection through wills and trusts. Recognized as a Super Lawyer's top-rated estate planning attorney in Maryland, Elsa combines legal excellence with a strong commitment to communities of color. A U.S.-born Spanish speaker of Afro-Cuban descent and a small business owner herself, she understands the estate planning challenges of first-generation wealth builders and women of color. Elsa is dedicated to changing the conversation around legacy, wealth, and ownership in historically underserved communities. She makes complex legal concepts clear and actionable. She also hosts Wills, Women, and Wealth with attorney Elsa W. Smith, a podcast and YouTube channel making estate planning and probate practical and relevant for her audience. Her leadership extends beyond her practice. Elsa serves on the Board of Governors and the Estate and Trust Law Section Council of the Maryland State Bar Association, and is a graduate of the Mid-Atlantic Fellows Institute of the American College of Trust and Estate Counsel, ACTEC. Her mission is clear: to empower women through estate planning and serve as a catalyst for transforming the generational wealth narrative in communities of color. Now I'll turn it over to our speaker of the hour, Elsa Smith.
Felicia, thank you so much. And good evening, everyone. I'm going to start by sharing my screen. And we are going to get this show on the road. And it should be queuing up in just a second. Wonderful. So welcome, everybody. Good evening. And thank you for joining us for Empowering Your Legacy, Estate Planning Made Simple. I'm Elsa W. Smith, managing member of the law offices of Elsa W. Smith, based in Annapolis, Maryland. Now, before we dive in, I want to take a moment to thank Maryland Public Television for inviting me to be a part of this important community initiative. MPT has a long history of serving Maryland families by providing trusted educational programming. And this webinar is another way that they're helping to empower our communities with practical information that can make a real difference. MPT and I share a goal to reach people who may not always have access to these kinds of conversations, to make estate planning clear, approachable, and achievable for everyone. Now, as you heard, my work centers on helping individuals and families protect what matters most through estate planning. Over the years, I've learned that estate planning isn't just about documents, it's about empowerment. My mission, and really the heart of my firm, is to make estate planning accessible, especially for women, families, and small business owners who may not always see themselves represented in these conversations. Tonight, I hope to demystify this process for you, to show that it's not intimidating or out of reach, but actually one of the most caring and forward-thinking things you can do for your loved ones. This webinar, as was said, is for general information purposes only, and it is not legal advice. Please consult an attorney for guidance tailored for your specific situation. By the end of this webinar, you'll understand what estate planning really is, why it matters, and how to get started. I want you to feel informed and confident about taking your next step. My hope for you tonight is simple, that you leave this session feeling informed, inspired, and ready to take action. Estate planning isn't just about documents or legal terms. It's about love, protection, and peace of mind. It's about taking control of your story and ensuring that the people you care about are supported no matter what happens. If by the end of this webinar, you feel a little more confident and a little more motivated, I should say, to get started, then I'll consider this time together a success. To make our time together more interactive, there will be polls that will appear a few times during my presentation. Just click your answer and submit. It only takes a few seconds and it's anonymous. So, what is estate planning, really? At its core, it's the process of making decisions today about how your assets, your healthcare, and your wishes will be handled, both while you're living and after you're gone. Now, many people assume estate planning is only for the wealthy or just for more older or seasoned adults. The truth is, it's for everyone, and that is all adults. Even if you don't own a home or have a large bank account, or you still have loved ones, responsibilities, and important decisions that deserve planning. Estate planning is about clarity, protection, and peace of mind. It ensures that your wishes are known, your loved ones are guided, and your family doesn't have to guess what you would have wanted, especially during difficult times. So let's begin with our first poll. Have you created an estate plan? Please take a moment to select your answer. We'll give about 10 seconds before moving on. Wow, people are really responding. This is great. That's great. I'm seeing the responses in real time, or at least the percentages in real time. This is great. Okay. So almost a third of you have completed an estate plan. A little over 30% have started, but it's not complete. And then the bulk haven't started yet, but that's okay. The goal of this webinar is probably to just push you a little closer to taking that first step. So this is great. Thank you so much. Oops. Share that. Let me stop sharing and we're going to keep moving. All right. Now let's talk about common myths. Even though estate planning is important for everyone, there are some common myths that can hold people back. Myth number one, and this is in no particular order, but myth one, I don't need a will. Many people think that estate planning is only for the wealthy, but in reality, it's about protecting whatever you do have, your home, savings, and sentimental items. Here's myth number 2. My family will automatically know what to do. How often have I heard that? Even the closest families can face confusion or disagreements without clear guidance. A plan takes the guesswork out of difficult situations. And myth number 3, everything automatically goes to my spouse. Laws vary by state, and without a plan, your loved ones might inherit differently than you expect. By understanding these myths, we see that estate planning isn't intimidating. It's a practical, caring step to protect your family. Time for our next poll. Now, which of these myths did you believe before today? We'll take about 10 seconds before continuing. Well, this is good. A majority of you are saying none of them. With that's heartening as an estate planning attorney to see. That's great. Yeah, and a few of you think you don't need, or at least you believe the myth that you didn't need a will. Unfortunately, that percentage looks like it's pretty small. Okay, let's go ahead and publish the results of the poll. Look at that. Great. I am so encouraged by these numbers. That's wonderful. So good. We're pretty much on the same page. Many of you do not believe these myths. So let's keep on moving. Great job. Now that we've dispelled a few of these myths, let's look at the core 4 estate planning documents. They are the foundation of your plan. They include your will or a last will and testament, the power of attorney, the advance medical directive, and the HIPAA authorization. Now, your will, this directs who receives your property, and it's where you name a personal representative to carry out your wishes. If you have minor children, the will also names a guardian you've chosen. Your power of attorney gives someone you trust the authority to handle your financial and legal affairs if you can't. Your advanced medical directive allows you to name a healthcare agent and makes your wishes known about medical treatment and end of life care. And then your HIPAA authorization ensures that your loved ones can access your medical information when it matters most. So together, these documents create a foundation that protects your family and you, both in life and beyond. Now, here we are. We see all 4 documents. Each serves a unique purpose. And together, like I said, they ensure your financial, legal, and medical decisions are protected. Now, we're going to go briefly through each one so you understand how they work together. Before we do that, though, our third poll of the evening. Do you currently have any of the core 4 documents? Please take 10 seconds to submit your answer. This is a good way of gauging where we are as a group. This is great. Some people have some of them, and then some folks don't have any yet, but hopefully that's going to change after tonight. Let's go ahead and publish those results, please. Excellent. So many of you have at least some of these documents, so that's great to know. And we're going to move forward. Now that we know where we are as a group tonight, let's take a deeper look at the core 4 documents, starting with the last will and testament. We'll explore what it does, why it matters, and how it protects both you and your loved ones. So your will is the document that speaks for you after you're gone. It names who should inherit your property, everything from your home and savings to those special items that carry sentimental value. It also appoints your personal representative. In some states, this is known as an executor, the person responsible for ensuring your wishes are carried out. And if you have minor children, your will is also where you can name guardians to care for them. Now, why does it matter whether you have a will? Because if you pass away without a valid will in Maryland, not the state, not you, decides how your estate is distributed. That can lead to confusion, delays, and even disagreements among loved ones. And here's an important tip. Your will isn't set in stone. Review it and update it whenever life changes. A new marriage, a divorce, the birth of a child, or new assets acquired are all reasons to revisit your will. In short, your will gives you control and provides clarity for your loved ones and ensures that your wishes are honored long after you're gone. Now, let's take a closer look at one of the most powerful tools in your estate planning toolkit. That's the power of attorney. This document allows someone you trust, your agent, to manage your financial and legal matters if you're ever unable to do so yourself. That can include paying bills, managing bank accounts, filing taxes, or even handling real estate transactions. Here in Maryland, a power of attorney is durable by default, and that means that your agent's authority continues even if you become incapacitated, unless the document specifically says otherwise. That durability is what makes this tool so essential. It ensures that your affairs can be managed seamlessly when you can't act on your own. Having a power of attorney in place spares your loved ones the time, cost, and stress of going to court just to gain permission to handle your affairs. It's about protecting your finances and giving both you and your family peace of mind. While Maryland provides a statutory form that most institutions will accept, every person's situation is unique. And with my years of experience, I can tell you that tailoring this document to your specific needs, whether you own a business, rental property, care for dependents, all of that makes a difference. In short, a properly drafted power of attorney isn't just paperwork. It's practical protection and an essential safeguard for your future. Next, let's talk about the advanced medical directive, often called an advanced directive. I'm using the term advanced medical directive to just bring home the point that this document specifically focuses on medical decisions and not financial or legal ones. An advanced medical directive allows you to appoint a trusted person, your healthcare agent, to make medical decisions on your behalf if you're ever unable to speak for yourself. It also gives you the opportunity to clearly express your wishes about the treatments you do or don't want, including life-sustaining ones. Here in Maryland, this is a legally recognized document, and it can be updated at any time to reflect changes in your health, relationships, or just your preferences. Having one ensures your voice is heard and your loved ones receive clear guidance. instead of facing uncertainty during really emotional moments. It's also wise, in my opinion, to pair that advanced medical directive with a standalone HIPAA authorization. Together, they allow your healthcare agent to access medical records and speak directly with your doctors, which is essential for coordinating your care and making informed decisions. In short, your advanced medical directive protects your health, supports your loved ones, and provides peace of mind for everyone involved, making it a vital part of your estate planning toolkit. And finally, let's talk about the HIPAA authorization. HIPAA stands for the Health Insurance Portability and Accountability Act. That's a federal law that protects your private medical information. A HIPAA authorization allows you to name someone, such as a spouse, adult children, or a trusted friend, who can access your medical records and speak with your healthcare providers. This becomes especially important if you're ever unable to communicate for yourself. It's worth noting that this document does not give that person the power to make medical decisions. Only the healthcare agent named in the advanced medical directive has that authority. Instead, the HIPAA authorization ensures your loved ones can stay informed, coordinate care, and support your healthcare agent in carrying out your wishes. When paired with your advanced medical directive, the HIPAA authorization completes your healthcare planning. Together, they give you control, provide clarity for your family, and ensure that your wishes are respected, offering peace of mind for you and those that you love. Now, while having some or all of the core 4 documents is a great start, some people want to take their planning a step further. That's where living trust or revocable living trusts come in, offering added flexibility and control over your assets, both during your lifetime and afterward. A revocable living trust is a legal tool that allows you to own and manage your property while you are alive and control how it's distributed after your death. Unlike a will, which only takes effect after you pass away, a living trust can be used right now. You, as the grantor, can place the assets into the trust, I should say, continue managing them yourself, and make changes or even revoke the trust at any time, hence the term revocable. One of the biggest benefits of a living trust in Maryland is that it helps your loved ones avoid probate for assets that are held in the trust. That means property can pass to your beneficiaries more quickly, privately, and with relatively less expense than it might through the court process. Living trusts are especially helpful if you own a property, want to plan for a smooth transition of assets across generations, or need to provide for minor children. They offer several key benefits. Privacy is one. Assets in the trust avoid public probate. Cost savings. They can reduce or even eliminate probate fees. Continuity. Your instructions for managing assets take effect immediately if you become incapacitated. In short, a living trust provides control, flexibility, and peace of mind for your family's future. It's important to note, however, that a living trust does not replace the core 4. You still need a will, power of attorney, HIPAA authorization, and advanced medical directive, in my opinion. The trust simply adds another layer of protection and convenience. So even if you have a living trust, your will remains essential. Here's why. A trust only controls the property you transfer into it. Anything you forget to transfer or acquire later, like a new bank account or personal items, won't automatically be covered. A will ensures that those assets go where you intend. Only a will can name guardians for minor children. Finally, a will acts, I guess the best way to look at it, it acts as a safety net. If your trust isn't fully funded or something falls outside of it, for whatever reason, you forgot to make a transfer, the will ensures that your wishes are still honored under Maryland law. So think of a revocable living trust as a powerful planning tool for managing your assets efficiently and avoiding probate. And your will is the essential backup that covers everything else, including guardianship and property not titled to the trust. Now, let's talk about funding your trust. Funding this trust means making sure it actually controls the assets that you intend. Some assets, like your home or business interests, must be formally transferred into the trust, making the trust the legal owner. Other assets, such as investment accounts, retirement accounts, life insurance, and bank accounts, can name the trust as a beneficiary. They do not need to be retitled. The trust receives them directly when you pass away. Vehicles work a little differently. In Maryland, the Department of Motor Vehicles allows you to name a transfer on death beneficiary to transfer the vehicle directly to a person. So your car really doesn't have to go into the trust, and it's generally not recommended. Using the correct method for each type of asset ensures that the trust functions exactly as you intend, giving your loved ones a smoother and more predictable process after your passing. Of course, every person's situation is unique, and working with your estate planning attorney, you can create a plan tailored to your specific needs and goals. Now, your trust and will work hand in hand. The trust manages the assets inside it, as I said, and your will covers anything outside or anything that was left out. Together, they form a complete, coordinated estate plan that ensures nothing slips through the cracks. Hypothetical. Imagine Sarah owns a house, a brokerage account, and a retirement account. She creates a living trust and transfers the house and names the brokerage and in retirement accounts as trust beneficiaries. She also creates a will. The trust will manage and distribute the assets that she put into it according to her instructions. The house and the investment accounts go directly to her beneficiaries without going through probate. But what about anything not in the trust? Let's say that Sarah also has a small savings account she forgot to assign a beneficiary to. Her will acts as a backup, directing, for example, that this account go to her children. In addition, Sarah's will can name guardians for her minor children, something the trust can't do. So the trust, again, handles the assets it contains efficiently, while the will ensures that nothing is left out and protects her family in other ways. Together, they make a complete and coordinated plan. One important note: any asset, as I said, left out of the trust that does not have a beneficiary designation like a bank account or investment account, like with, for example, without a payable on death designation, must go through probate. Probate is the court supervised process of distributing assets, which may be time consuming, public, and often costly. That's another reason why it's important to fund your trust or ensure assets have proper beneficiary designations. This way, you can help your loved ones avoid unnecessary delays and ensure that your wishes are carried out smoothly. Time for our last poll of the evening. Would you consider a living trust as part of your estate plan based on everything I've shared with you? Please submit your response now and we'll pause. We'll wait, I guess, for about 10 seconds for folks' responses. Oh, this makes my heart smile. And you all are listening, paying attention. I love this. Okay, let's publish those results, please. Outstanding. Outstanding. This group, this audience is really with it tonight. And it really makes my heart happy that you all at least are considering including a trust as part of your comprehensive estate planning strategy. Let's move on. All right, so here is a simple way to think about your estate planning toolkit. The core 4 documents form the foundation. Now, there may be others, but for purposes of this presentation, I'm just focusing on these core 4 documents. They form the foundation. And a living trust can provide extra control and continuity. Your next steps are easy. Review what you already have, identify any gaps, and work with an estate planning attorney to create a plan tailored to your family. This is how you empower your legacy. And one point I wanted to mention as you're reviewing your documents, if they're, say, older than maybe 4 or 5, years old, even 10 years old. We've had folks contact our office with wills that are 10, 15 years old. They definitely need to be updated because life changes, your preferences change, and it's always a good idea to refresh those documents based on changes that happen in your life, as I've mentioned earlier in this presentation. But having those, I guess, outdated, it could be an outdated document based on what your life circumstances are right now, can bring a lot of heartache to you and your loved ones. I can't tell you how many times, for an example, and focusing on an outdated will. A person dies with a will that they created maybe 10, 15 years ago. The person, the deceased, married again and had children, but there were no provisions in the will or any kind of estate planning for, this new family. But the will said what it said, and it doesn't really reflect the situation the deceased had at the moment of his or her passing. So that just brings a lot of heartache, confusion, and could have easily been remedied by just updating those documents or that document to reflect the person's current situation. So now that you know key documents and what the key documents are and how a trust and will work together, it's time to take action. Begin, as I said, by gathering the documents you already have and review them carefully. Look for gaps. Maybe you don't have a power of attorney and you need one, or your trust isn't fully funded. The next step is to schedule a consultation with an estate planning attorney who can guide you through tailoring a plan for your family. And remember, estate planning doesn't have to happen all at once. Even starting with one step today puts you on the path to protecting your loved ones and empowering your legacy. Before we move into the Q&A segment of this presentation, I want to tie everything back to the goals of today's webinar: making estate planning clear, approachable, and achievable. It's clear. You now understand the purpose of key documents and how they work together. Estate planning is approachable. Estate planning is for everyone, all adults, not just the wealthy. And you can start today, even with small steps. And lastly, estate planning is achievable. There are concrete actions that you can take right now to protect your loved ones and your legacy. Every step you take is a step toward empowering your family and securing your legacy. I want to thank you all so very much for being a part of this conversation today. I hope that you're leaving with greater clarity and the confidence to take your next step in protecting what matters most. A special thank you to Maryland Public Television for the opportunity to share this important message and continue empowering our community through education. It has truly been a pleasure spending this time with you, interacting with you, and I love the participation through the polls that we've shared during the presentation. I'd really at this point love to hear your questions, and I believe at this point, Kalisha is going to come back on screen, and I'm going to stop my share. Thank you all. And if you want to stay connected with us, by the way, make sure and scan the QR code that's displayed on your screen right now. That's a great way to stay connected and keep abreast of news and events that are happening with our firm. Again, thank you so much for your time.
Okay, thank you so much, Elsa. That was very clear and understandable, and I took down a couple notes to move forward. Okay, let's go through some Q&A. I'm going to go through the beginning here. So I have first question, what is the definition of an estate plan? I believe you answered that question in the beginning. Then if there's a medical power of attorney, does that include the HIPAA authorization?
That's a great question. In Maryland, the Maryland Advanced Directive does have a clause in it that addresses the HIPAA authorization. But the reason I recommend that you have a standalone HIPAA authorization is just really for convenience. Many medical facilities, hospitals, they want both. So it's a good idea just to have them both. But the questioner is correct that, to at least point out the fact that, there is that HIPAA authorization in the document.
All right. And then what about a MOLST, MOLST?
Right. For those who are looking, who do not wish to be resuscitated, that is one, another document. It's outside the scope of this presentation, but yes, that is another tool that is available to you.
And does your will need to be filed with the Office of Wills?
That would be with the Register of Wills. Technically, no, but I highly recommend it. For every estate plan that I've done, I always recommend that your will be registered with your Register of Wills, and they're located in the county in which you reside. And currently, it's only about $5 to register your will, and the original remains in their vault. It's safe waterproof, fireproof, all that. So I highly recommend it. Better than, we've heard celebrities that are, putting wills in like couches, sofa cushions, and all that. Please don't do that. It's easy, and you can always keep a copy in your own records, but at least know that the original is with the Register of Wills. So I highly recommend it if you do have one to register it with the local Register of Wills.
All right, I think there's a lot of the same question. Oh, it jumps around. So, what is the difference between advanced medical directive, power of attorney, and executor for when you're completing your will?
Okay, two are like tools and one is a role. The executor, as I mentioned during the presentation, is in what the term is called in other states. In Maryland, the person is known as a personal representative. Think of that person as like your point person when, after you die. The person, that trusted person that you choose to manage your affairs after you die. So that's personal representative / executor. The other two items are tools. Now, you said you referenced what, the advanced medical, and what was the other
And
one?
and the executor. So
Well,
I guess
the executor, I addressed that. What was
and
the
power
other?
of attorney.
Okay,
With power of
right.
attorney, executor, and yeah.
Right. And we covered this, and hopefully when everybody who registered gets the replay,
They
please
can
feel free to, it's a tremendous resource to go back and play uh, what I talked about. I covered each document. The power of attorney, again, is only effective while you are alive. And it gives a trusted person. I always say that, you're giving them the keys to the kingdom, because the person, that trusted agent or attorney, in fact, has the power to do everything that you are authorized to do. Right. And let me add another point to that. You can revoke the power of attorney. The law only requires that you communicate to the agent that you no longer wish for them to serve as a power of attorney. Like I already said, that it's revoked automatically when you die. It broad powers. So choose carefully. Many of the, for all of the documents that I talked about tonight, there's like a thread that runs across all of them. And that is, you need to have a trusted person in each role. And in my practice, I tell my clients, I said, here, we do not make decisions. We do not choose people in these important roles out of guilt, pressure, or obligation. So I'm going to pressure you to think about the person that you're selecting. Do they have the skill set? You want to put someone, position them for success, right? So if you're considering a power of attorney agent who always overdraws their bank account, kind of shifty, shady, kind of not responsible, sorry, they can be a beautiful person, but I'm not going to recommend that you choose that person as your power of attorney agent. And I tell my clients, I'm like, listen, you can tell them, my attorney recommended that I not appoint you. I said, blame me, because I need you to have clarity. These are the people that are going to be responsible, acting on your behalf. If you're intubated in some hospital, if you're in critical care, you don't want someone who's shifty, unreliable, handling your finances, for goodness sake. And with respect to the medical directive, same point. You want someone, and you're not expected to be, to have medical training, right? Nobody's expecting that. But ideally, you should have someone who has the temperament to make decisions, to listen, to be able to communicate with your healthcare providers. Because if you're in a position where the advanced medical directive kicks in you're in a pretty serious healthcare situation, right? And at worst, you could be at the point of death or near death, I should say. And, you know, just uh, just sharing a little bit about my story. My mother passed away a number of years ago of stage 4 glioblastoma cancer, and I remember being meeting with her doctor, her team, oncology team, with x-rays and results and talking about options. And I was fortunately doing this with my siblings. But the point is that you need to have someone that has that temperament, that's not going to fall apart, and at least is able to take in that information and make the best decision for you. Underline that, okay? Because every person in each of these positions are what are called fiduciaries. They are required to act in your best interest. If they can't, don't put them in that role, please. It's not about them, it's about you. I know I get really passionate about appointing people to these positions, if you didn't notice already.
Okay. A lot of these questions are repeated, so I will
Mhm.
try to match them all up.
Okay.
So, are the four estate planning documents have specific templates or forms by the state, or do they all need to be created with an attorney?
Well, the power of attorney is a statutory form. It's been authorized by the legislature. So that is available. And then the advanced medical directive generally also is pretty standard. Where you're going to see a lot of variance. Oh, excuse me, and the HIPAA authorization as well. So where you're going to see a lot of variance is in the will, because as people are individuals, so are wills, right? So, but another important thing I want to add, that it's more than just grabbing a document. You need to make sure that it is prepared and it is executed according to Maryland law, because if they're not, then you're opening yourself up for those documents being challenged because they weren't witnessed properly, they weren't notarized if a notary is necessary, and that can really just tank your estate plan.
Yeah, that goes into the next question where it says power of attorney is the power of attorney effective as soon as it is signed, or only if it is if only you are incapacitated. And I'm
It all
like,
depends. Great question. It all depends on the terms that you need. There are, for the vast majority of individuals that we serve here at the firm, they don't need the power of attorney to kick in right away. We add language that's known like a springing provision, that it only kicks in if certain situations arise, right? So no, it does not need to be activated right away.
and I don't know if I answered this one, but does the medical power of attorney take the place of a HIPAA release?
We kind of addressed this already.
Okay, in the first
Right,
question. I
right.
just wanted to make sure I didn't mix that up. Okay, now
Sure.
this is a lot of the same question, so I'm gonna try to combine. Um, they say, I know many people are putting their homes, cars in a trust for their kids. What is the advantage to the trust versus a will that indicates home, car to kids? And then, if you have no children, do you really need a revocable living trust?
Okay. Let me take the first one in pieces, because the person said home, car, and something else.
And yeah.
During the presentation, and I don't know if the viewer had a chance, was on when I covered this part of the presentation, but I said that it's generally not necessary to put a car in Maryland, to put a car in your trust. There are easier ways, and I mentioned that the Department of Motor Vehicles allows you to do what's called a transfer on death beneficiary designation, that transfers that car directly, like at death. And the car doesn't need to go through probate, and it certainly doesn't need to go into the will. Right. And there's another part to that question too.
Yes,
Sorry.
about do they really need the revocable living trusts?
Oh, if they don't have kids?
Yes.
Yeah, here's why. Because revocable living trust takes care of you while you're alive as well as when you pass away. So if you're incapacitated, you need instructions on how things are to be managed. And depending on, how many things you have going on, you want to give people a roadmap. The point I hope that everyone takes away from this is like, please don't just throw your caution to the wind, leave it up in the air and say, well, my family will figure it out. We address this as one of those myths because, first of all, it's not fair. And, some people, and I can get pretty direct. I mean, they like to put their heads in the sand because they don't want to deal with it. And if you don't deal with your affairs, take care of your business, you're leaving it for somebody else to do. Right. And that's not fair to them. And I personally don't think that that's the legacy that you want to leave. If you were a person all through your life, you worked, paid your bills, worked hard, was a generally decent person, and then at the last stage of your life, you just said, I'm not here anyway. I don't care. They can do whatever. Is that the legacy that you want to leave, which is contradicts the person that you were for however many years you were alive? So I just want people to just take ownership, and exercise some agency so that your family is not left in chaos. Because let me tell you something, death and money do weird things to people. And people who are normally rational, clear thinking people can just go berserk when there is no plan in place. Let me give you the example that I always like to share with colleagues and with clients too. Person dies, there's no will, there's no nothing, and funeral arrangements need to be made, right? So maybe the person closest to the deceased is like trying to put something together, and then you have people coming out of the woodwork going, well, I want to be on the funeral program. What? Well, I think it should be this, or I think it should be held there. And all of these people putting their 2 cents in, and it's pure chaos. And you have disagreements, and those disagreements actually have torn families apart, in all seriousness, just because no one had foresight to just put a plan in place. And it doesn't have to be elaborate. Just put something down, put something together, work with a professional. In our communities, we need to really, two things. One, bring estate planning to the dinner table. I want to see more families having these frank conversations, not just when somebody dies and not just at the family reunions. I want this to be normalized as part of dinner table conversation. And two, I want us to get comfortable, or in some cases more comfortable, with working with professionals. You have your CPAs, you have your financial advisors, your estate planning attorneys. Just like for those of you, if you own homes, you have a gardener, a plumber, somebody that comes to do certain services. Let's normalize having these professionals around you because, quite frankly, you can't do everything yourself. I run a business. I have people, I have companies that assist me because I leave it to the experts. I want to focus on what I do best and what I enjoy, which is estate planning. So let's get comfortable with that. And there's plenty of information out there. My website, for example, elsawsmithlaw.com, has resources, but there are other resources. Get familiar. It's great that you all are attending webinars like this, and I applaud Maryland Public Television for just taking that step, taking that initiative, because it's so important. We need to keep putting that information out and serving.
Now, this person said, if no children, spouse, or immediate next of kin, where would the estate go to?
Well, It all depends.
Oh, and then to add on to that, if
Okay.
there's beneficiaries listed on an account, will that be honored if there is no will?
Yes, yes. And that's kind of like my point. That's a great question. Yes, if anything that has a beneficiary designation, that will be honored. And it actually trumps anything that you might say, if you had a will, right? Because the law looks at what are the beneficiary designations. Now, for the person that said if they don't have, they don't have kids,
Hmm.
they don't have a spouse,
Yeah, they
well,
don't, or next of kin.
or like next of kin, and do they have an estate plan or do not have an estate plan?
They won't have an estate plan.
They
Yeah, if they
won't have
don't.
an estate plan. Well, you know what? You're leaving it to the state, and you're governed under your state is governed under the intestacy laws. That's for people that die without a will. So um depending on that particular situation, they may go up the bloodline. They may look at parents if the parents are alive. And if absolutely no one is available to inherit or accept assets, I believe that it goes to the local oh great, I believe it's the local school board or whatever. It happens so few and far between, but yeah, the state does have a plan if you don't, in a nutshell. They're not going to let that money just go just sitting there if there's no one to inherit.
I'm going to dismiss a couple of these because they're specific questions.
Sure, thank you.
Um,
Yeah, folks, and if for those of you who do have like kind of personal specific questions, they're not really appropriate for this like public context, but I encourage you, connect with an estate planning attorney and have those, private, what should be private, attorney-client privilege conversations where you can fully explain what your situation is.
um, um, do you have a sister firm? Is it just your one office, or do you have other?
Oh, well, the law office is, yeah,
Yeah.
my office, Prince George's County and here in Anne Arundel County, but the
Okay.
main
The
office
person
is.
was looking for California. Yeah.
Oh, okay. Well, listen, great. I'm glad you asked. Fortunately, I'm blessed to just be connected with people all across the country, and I'm often asked for referrals. So if we can help you, because you're out of our jurisdiction, please know that chances are that I will have a contact. So you can feel free to contact the office. Our number is 410-995-7719. And we'd be happy to at least try to find someone for you in another jurisdiction.
Okay. Cost of living trust, cost to have a will and trust prepared by an attorney, I guess costs in general.
Yeah, no. And it's a question that we get in the investment really depends on your particular situation. This isn't, well, I tell people it's not like you're going to your local fast food joint and you're like, I want number two on the menu. At least the philosophy that I have is that I want to, we do offer like a complimentary 15-minute assessment call, in at least in our office. I don't know what other firms do. I know what our firms do. And it helps to at least give us an idea of where you are and whether you're going to be a good fit for us to move forward, and then schedule a meeting to meet with me. At that point, I can assess your entire situation and then really give you a strategy, a game plan. You don't have to, agree with it, but it's going to be my recommendation based on what you've communicated to us. And then at that point, I can give you a tailored quote for your specific situation.
What are some important what is important when looking for an attorney, estate
Ah,
planning attorney?
wonderful, wonderful question. If you recall at the beginning of the webinar, and as well as Kalisha's introduction of me, I am very involved in the estate planning industry, if you will, the world. I am a member of the Maryland State Bar Association's Estate and Trust Law section. It is the governing body of estate planning attorneys within the Maryland State Bar. What does that mean? That means that I am in community with other estate planners who are really dedicated to what we're doing, right? And to answer the questioner's question, have they published anything? Do they provide videos, complimentary videos to kind of educate the public? In addition to a very robust YouTube channel that I curated over years dealing with estate planning topics, I also have a podcast, the Wills, Women, and Wealth podcast, that's available on Apple and Spotify. Again, free, right? Addresses estate planning topics. Is the person that you're considering not a jack of all trades? Do they have a concentration in estate planning? It's okay if like one or two areas of law, but if you've got an attorney that does 50 million things, I mean, how dedicated are they going to be? How focused are they really going to be to estate planning? And those are the things you want to look for. And aside from the obvious, the qualifications, and the firm focus, this is a people industry, right? If the attorney does not have a heart to serve, in my humble opinion, they've got no business doing what we do. Because I have people coming to us, sometimes in very vulnerable times in their life. They may have lost a loved one, and that triggered the need to I need to get my stuff in order because I just came from a funeral 2 weeks ago, right? And in my opinion, you want someone that has, and I think this is something that frankly sets our firm apart, cultural sensitivity. I am blessed to serve people of all different walks of life, all different socioeconomic, educational levels. And I learned so much from my clients. They have made me a better attorney because they trusted me enough to share their experiences, their individual family dynamics. And I've assisted them in navigating through that and creating a plan so that when they leave, they're transformed. They're walking taller. They're breathing just a little easier, right? If your attorney, attorney you're considering, doesn't do that for you, isn't interested in transformation, and is just churning out documents, I mean, that's respectfully something that you ought to consider. It's all about the experience that you want. Do you want to be transformed? The mission of my firm, as you'll see in my website and many marketing materials, is that I want to empower women through estate planning. Now, do we serve men and everybody? Yes, we do, gladly, right? But I focused, and this goes to my mission, I focused on women. And why don't I tell you a bit about my story while we have a couple of minutes? I didn't have an estate plan until I got married roughly 18 years ago. It was my first estate plan. And I was an attorney, but I got an estate plan, and I felt so different when I had my portfolio. I'm like, wow, this is what grownups do, right? And then years later, and the reason why I decided to, pivot and become more focused as an estate planning attorney is because I wanted to recreate that feeling amongst women in general, and then women of color in particular, women who look like me. Why? Because in all the marketing that I saw, I didn't see that folks were talking about me. So the message that communicates is that I don't belong in the conversation. I disagree. And I and other attorneys who believe as I do are doing our part to change that narrative. And how do we do that? By one client, one family at a time. Because if you come, we create your estate plan, and you leave, you're taking that back to your family, your circle of friends. And then you are that pebble in the water, and that creates a ripple effect, because your environment has seen something different, perhaps something that has not been done before. And you have the power to change your family's trajectory, your community, just by you being a trailblazer, right? And it's all because you took initiative. You wanted to take control, and you wanted to just have a different legacy, than what was done before. You may be what I call first generation estate planners. Maybe grandparents had just had life insurance and nothing else. Maybe a will here, something there, but nothing ever comprehensive. And then here you come with a complete estate plan. You're going to make sure that your needs are met while you are alive, as well as giving a roadmap to everyone to handle your affairs when you pass away. I just wish people would understand the power that has, that relief that people have in knowing that there is a roadmap, there's a blueprint for going forward, and you influence an entire generation, one person at a time. And we've got a lot of work to do, but I'm encouraged by really everyone who joined us this evening, by the responses that we got on the polls. People are thinking, the seeds are being planted. And my hope is, and it doesn't have to be with me, I would love to serve you, but find a qualified estate planning attorney. Take that step and just take control of your legacy. As I always say in my podcast, be empowered and take control of your legacy.
All right, I'm going to just answer a couple. There was a whole bunch of questions. I'm going to try to group them all into one.
Sure.
If somebody has um, a will in Maryland, but then they pass away in a different state, how is that handled?
At least it's what they'll look at is where you were a resident. If you died as a resident of Maryland, that's where my understanding is that's where the will, and then specifically the county, and that's where the probate should take place. Now,
Even if the executor is in a different state?
if the
I mean,
personal
executor. Yes. Yes.
the personal representative,
Yes.
yeah,
Representative.
as long as now here's the thing. In Maryland, they're going to need to have in that case a resident agent, someone that can accept court papers that resides in Maryland. Now, the way around it sometimes is if they're working with at that point we're talking about probate, right? Estate administration. And a Maryland attorney can, though doesn't have to, but can serve as that agent if the personal representative resides in another state.
Okay. And then I had a bunch of people ask about if they can get a list of attorneys. That I can provide a list of attorneys in your area. That'll be information that I could put in the follow-up email that I send out to you guys. There were a whole bunch of other questions, but we do not have time to finish them.
Obviously.
But if you guys can, once I send out the follow-up email, if you have questions that you want to send, you can always reach out to Elsa, as well as me. You can visit mptlegacy.org to download a free estate planning guide that will help you create your will. And then we also partner with Free Will. So if you go to mpt.org/free will, you can create your will online for free. And that's a tool that we offer through MPT. Elsa, thank you so much for taking the time to educate us this evening. And we ask that you guys please complete the survey that will be sent out to you all. And as always, thank you for attending MPT's Major in Plan Giving Estate Planning webinar. And I look forward to hearing from you guys in the future. Thank you.
Alicia, it's been a pleasure. Thank you to MPT very
Thank
much.
you so much.